Okay. What's going on, man? A lot of drama.
I gave this case.
Yes, absolutely. What is?
2502034.
Page 17.
On Juarez?
Oh, no, this is a different case.
Oh,
Yeah, the other one I want to talk.
On Guillermo Juarez?
Yes, sir.
Okay.
So we're in the ERD and it's set for trial Monday. I'd spoken to Judge
Singer?
Singer. And he said, they're talking about doing a time served on the case. They have these rules there. He said, why don't you go check this Fleischer and see if he's okay with that? He goes, I'm fine with that. He's going to
With the time served? Yeah, I mean, I don't see why not. Do you want to do it? Is he here?
No, but I'll get him in here.
Yeah, it's up to you. I mean, you guys, if and you said it, I don't know. I mean, I don't tell people normally that, when we set a case that they're, barred from pleading, unless they're playing games. And I know that they're playing games, but
So they have that they have certain things they do. So when I talked to him, he said, no, you could just go talk to him. He goes, I'm totally fine if he's.
and I am okay with it too. If you want
It's
to,
fairly, not that these are mild, but it's one of those kind of.
whatever you want.
Okay, I'm gonna bring him in.
You spoke with Sebastian already, the prosecutor on the case about time
Do
served.
you have that offer, Marco? Do you have that offer?
No, it'd have to be, that's what I'm saying, it'd have to be right.
Oh, with that agreed rec?
Yes.
Oh, well, you didn't say that. I assumed that.
That's why we're gonna get Sebastian here, and you have to talk with defense first.
So read it. What happened real quick?
So in this case, it was back in March. The officer was dispatched to an assault family. The officer made contact with the complainant. The two shared children are in a dating relationship, and while the defendant was driving, the complainant was in the passenger seat. They got to a verbal argument. The defendant punched the complainant on the left arm. The complainant told the defendant to stop hitting her and then said that she would call his mom. The defendant punched the complainant in the arm again, and the complainant grabbed her phone and called the defendant's mom. The defendant punched the complainant for a third time in the arm, and the complainant said she would call the police. The defendant struck her 2 more times in the same spot, causing pain. The defendant pulled over, and the complainant and her child got out of the vehicle, and the officer noted visible injuries on the left arm.
Okay.
So
Well, I know what the DAs cannot do time served, even if they want to. So that's why I went to the judge, Singer, and he said,
I'm
fine with that.
yeah, I'm amenable.
So then I'm gonna bring him in.
Okay.
Okay, and then I'll email Sebastian.
you email Sebastian.
I mean, I know what his answer is, but it's really up to you. So he said, okay, thank you, Judge.
Yeah, I'm open. Hi.
I'm approaching Clayton Hodges on the docket today.
Marco, let him know that there's an affirmative finding, right? So
Oh,
that
yes.
he picks up another one. He's looking at a third degree,
I'll make sure.
Okay.
Back in October, on his bond conditions, you put a no driving restriction.
What's the name?
Hodges is the
Is
last
he
name.
here today?
No, it's waived. So to amend the bond conditions, do you need to see him? Okay,
Yeah, I like to admonish him
okay, well, I'll get him in.
and we'll,
Well, would you be willing to, because I hate for him to come and we're not willing to.
I mean, it's been how long?
It's been since October. He does electrician work. So I know we kind of amended the curfew last time, but he still has
You
the
have
no
two
driving
DWIs or just
restriction.
one?
I'm sorry.
2 or 1?
He has one DWI.
It's two open DWIs is no, but if it's just one and it's been that long and it's been like one of those, he had alcohol in the car.
But there's reason to believe that he may have been drinking and driving in this incident.
Right, well then that's why we take it as a part of the bond conditions. I say no driving. And then usually what we do is we wait a little bit, we want to know that they appreciate the fact that, and then,
That's a driving course. It's been since October.
great, bring him in. Yeah,
Okay.
I'm cool.
Okay, I agree.
Yeah.
Okay, thank you.
Mr. Booker, hi.
Judge, on Tarleton Stevens, I'm approaching just due to the age of the case. State offered a long probation for her, and we're working on a mitigation packet. We'd like to,
On Torlin, Stephen?
Tarleton Stevens, Judge. Yeah, I think she would be,
PTI?
I think she would be good for it, but we're just working on mitigation. It's taking a little longer than I anticipated. Would you be opposed to a couple of weeks to get it all resolved?
No, but it looks like you were saying a straight probation or
Yeah, she was offered a 15-month probation.
she don't want to do PTI?
That's what I would like, but it hasn't been offered. So we're working on trying to get her mitigation because I believe she has.
Just because it hasn't been offered doesn't mean that it's,
I think that's where we are now, Judge.
Mackenzie, is that off does she have a prior DWI or something?
She has no priors, Judge.
I'm not seeing the case. Is it an off docket?
Stevens, no, she's on.
Okay.
She's just waived her
Is
appearance.
it accident, high BAC?
No, the BAC was high, Judge, but there was no accident.
How high are we talking?
.19.
Yeah, I think just mitigation.
Okay, so we're still working on it, but she's good. I
Okay,
contacted her.
so how long you want?
A couple of weeks would be great. We'll get it done.
Weeks?
Okay,
Just not done. She's got to be here.
understood. Thank you. Thank you, Steve.
Yeah.
Yep.
Darla.
This is a file for this.
Okay.
We're associating that on your docket.
So what's the word?
He's gonna do what the state asked of him, so we worked on an agreement that's gonna end in both of the cases.
Is this a PTI?
Yes, Judge.
Okay.
But this morning, we received a bond violation reports also, just wanted to bring it to the court's attention.
I don't know. I mean,
It's not that he did anything.
it's Tasia Mitchell, right?
Mhm.
Tasia Mitchell, come up.
He lives in North Carolina, so he's not even here today.
We're set for trial.
He's going to dismissal today. We're gonna do all of that today. Like, he's almost done. They're an hour ahead of us. I spoke to him on my way to court. He is deep into
He had a bond violation?
He didn't have one until this morning.
Yes, it was just submitted this morning, Judge.
What is it?
It was just it's not compliance with the drug testing report. He hasn't checked in with our system since, I believe, the very beginning of December.
So here's what was happening. He was calling in and his number was getting kicked back. So he called pretrial services and was asking them what, or was trying to get in touch with someone to ask them what's happening with my number. He does not want
Look.
to exclude.
Let's do this. If you've got an agreement and you're telling me that he's going to work the dismissal today, he's got until the end of business today.
Yes.
Otherwise, I'm issuing a warrant.
Yes,
Because
Judge.
he's supposed to be here. There's a bond violation. So if you get the stuff done to where it gets dismissed, great. Otherwise,
Yes.
okay? So just let me know.
Yes, Judge.
It's on you guys.
Absolutely.
Okay? Marco,
Yes, sir. So I got appointed this morning to Meyer, MEIER.
Page 17.
okay, so
I called him, I just texted him, I hope to hear back from him, but I didn't know you were gonna be Trump, but I just wanted to catch you before you got
no,
started.
we're not, I don't think we're going.
Oh, okay.
We got some kind of message that he said he's in rehab.
Yeah, so he says he's in a psychiatric
Or
hospital.
yeah, that's what it
To the 14th of February. I mean, I can verify that, Torino, I haven't.
Pointed you so that you can get actual proof that we know that he's actually in there and not just blowing us off. If you need a couple days, we'll give you up to a week.
Oh, you just give me till, a couple days is fine.
So, but if he doesn't give us anything, then I'm gonna revoke his bond because this is already 2 to 3 times that we've already done this, you know?
So when I talk to him, I'm gonna find out exactly where he's at and then I can
Yeah,
verify.
but we need proof. I'm not gonna take his word for it.
Okay,
Yeah.
so you wanna just stick it back on Friday and I'll give you a chance to find out?
Vic,
Yes.
I think it's any day but Friday because Fridays are rainy days, so
Thursday.
sure.
All right, thank you.
Mr. D,
Judge, I'm here on Mr. Edward Brandon, Burton. Thank you. Edward Burton, he had gone yesterday, Your Honor, to take a drug test. It's my understanding from talking to pretrial services that my client had tested positive for cocaine,
come up, Mr. Burton.
methamphetamines, and marijuana.
We sent him for a drug test yesterday.
Bond violation for the.
He tested positive for methamphetamine, cocaine, and what else?
THC.
No, sorry. Goes with you. No, sir. It's unacceptable. Can't be using. I'm not going to talk to you. We'll let you talk to your lawyer. You tell me, but
Council for reset.
counsel, you need me?
I'm sorry, I thought you had called someone.
No. You're okay. What's going on? Hi.
I'm here on a Treadwell. This Treadwell is in the jury box. There's a few things to address, Your Honor. There is a bond violation currently right now, and we of course want to address that. I believe it occurred on the 19th of January. her being, I think, either 14 or 17 minutes late, against the curfew. And so when I spoke with my client on this, she explained it as far as what the situation was. This was the Friday right before the big snow, and everyone was going crazy. Of course, we all anticipated like it was going to be the last freeze. So she went to the store to be able to get supplies and load up on all of the necessaries, as everyone felt they should. And of course, the stores are crowded. Traffic is everywhere. Prior to going to the store, my client took her 3-year-old daughter to her 70-year-old aunt's house. And the reason being is because, one, her daughter is special needs and she just does not do well in the social setting. And recognizing that it was just craziness, she had to take her there first. Lines along, everything, once she leaves the store, it's apparent that, she very well may not be able to make curfew, but she did have to go get her daughter.
So we only have the one violation at 7:15.
That's correct.
Is that it?
That's it.
Okay. Come up, Mr. Treadwell. Ma'am, it's not the end of the world. I get it. But bond conditions are bond conditions, and you have 2 open DWIs, and you must understand that you and I are operating under strict compliance. I will give you a pass now. It's not going to happen again, though. Do you understand? Okay. All right, counsel. We're good to go.
Other matter, Your Honor, we did also want to approach on the court's consideration, or more so reconsideration of the recommendation for inpatient treatment. Now, we visited this previously.
Correct. And every time I deviate from said thing, we end up regretting it.
And
I mean, 10 times over. So
you shared that with us last time. I do understand that. I at least want to do my client a little justice and at least giving some reasoning behind why we believe outpatient would be a little more appropriate. So the first thing is my client, she has been sober for 103 days. She has exercised diligently and staying committed to sobriety. While she has been released, she has been regularly attending AA meetings, meeting with substance abuse counselor who just had a home visit with her a few days ago. She has obtained her health insurance, which was previously lost due to the loss in employment, but now she can further recovery by taking advantage of the psychiatric care, therapy, and whatnot. And 2, and this is really primary, the family circumstances. The circumstances of the family are the type that requires my client's presence at home. She is the primary caregiver of 2 daughters, ages 10 and 3. The 3-year-old, as we shared before, is a special needs child. And when she was in custody after the second offense, it was her parents who did take care of the children.
so luckily we have that going.
Well, yeah.
Have someone to watch the kids.
Yeah, and that was for just about 30 days or so. Definitely operated as a hardship as the parents. And of course, in these kind of situations, there's going to be sacrifices. Sacrifices has to be made by all parties. But we're talking about now 180 days, 6 times that amount, which, again, I think it would be a tremendous hardship. And particularly with, I think a lot could be said about it, but particularly with the special needs child, what we do know about that demographic is they need routine. Routine is keen in their lives. If that is removed, it's, they could get discombobulated and it could operate as a crisis to them. So what we do know is if she does have to go to this outpatient program, home is no longer going to be there. They're going to have to move with whomever.
You say she doesn't have health insurance?
Oh, she does. She does now. She obtained it as of July 31st. July 31st, right? Yes. I'm sorry, January 31st, excuse me. But yeah, so they would have to move. They would have to switch schools, just uprooted from the life that these girls do know and understand. And again, particularly with the special needs one, possibly not even be able to attend, is it occupational therapy? Speak, and occupational and speech therapy. Thirdly, Your Honor, when early on in this case, I had acknowledged, I had informed the court of my client, she is prescribed Adderall. And at the time of the offense, during the time of these offenses, her therapist had, they were adjusting her meds, even had her on an extremely high dose of Adderall. And, I don't want to portray myself as an expert in this at all, because I just found this information out. And that is that Adderall with alcohol, of course, that's a bad idea already. Okay, but what it does on a molecular level, they're both fighting for enzymes, and the enzymes are what's extracting it, getting it out of the body. The effect is that they mask each other. And so someone that is drinking while on Adderall, they're drinking, they're not feeling the effects. They're drinking and drinking. Your body is not telling you, okay, hey, we're intoxicated. But all the while, of course, the blood alcohol levels are through the roof, even to a fatal level in some instances. The blood alcohol levels here they're up there.
How high are we talking?
High, Your Honor.
Yes, Judge.
Yeah, no, and I understand, and that is
You realize that most people at that level, 0.4 is dead,
That's right.
right? You're at a 0.4, you're dead. At a normal person at 0.3, they'd be passed out 3 times over, right? It's to be able to get to that level at a 0.3 and then a 0.2 on that truly tells me that there is an issue there.
Oh, absolutely.
Right? And me, with that kind of levels, right? And we have 2 open DWIs. If I don't follow the recommendation, because that's why we have these people. They're clinicians, they're experts in what they do. They make the evaluation, they make the choices. I understand it will create a hardship, but sometimes that's what needs to happen to gain perspective and to gain knowledge. I understand your plight. I understand your position. Every time I deviate, you regret. She has a 0.3 and a 0.2. What was it? 0.28. A 0.28 and a 0.3 on 2 different DWIs.
That's correct, Your Honor.
I'm sorry. Just,
And again, I know that
I
that is
understand.
directly
I'm never going to be
attributed to-
a lawyer for, zealously advocating, and I appreciate it. And, you have to do what you have to do. I understand. Sorry. It's too much. If it was a 0.4 or a 0.14, but we have a 0.3 and then we have a 0.28. Really, it's too much. I don't know how you want to move forward, but I am sorry. I don't want to deviate from it. We can give you time to make arrangements, but I think that that's the appropriate course of action. I'm sorry, Ms. Treadwell, because there are consequences to actions, right? And I know that it's going to be hard, but I think it's going to be all for the better.
Your Honor, I absolutely agree that, when we're talking about treatment, who can speak against that? And I do understand that.
And we're giving it to you for free. You get out there, you're going to have to pay for it on your own. You're going to end up thousands and thousands of dollars to pay for it. I can't pay for a treatment on the outside. I'm telling you, I know that you have insurance. Insurance is only going to cover a portion. When you go to these outpatient treatment programs, they're thousands of dollars.
There is also the KEYS program and the Access program that, not really.
No, she's a 0.31 and a 0.28, really. That needs a lot. That's why they recommended it. And I'm sorry, but, I wish I could make a different decision, but sometimes we have to make tough decisions as well, and I'm sorry, Ms. Treadwell, but I will give you as much time as you need to make arrangements, but I truly think that that's the best and appropriate course of action. Okay.
How much time?
I mean, your first case is your second case is 104 days. The first case is 153 days. So you've got some time, but I mean, we're running up against it. You know, I'll give you another 30-day setting. But that's it.
Your Honor, would we give it 45 days? Because there's gonna have to be some major movement that is done on her end, to even try to get someone and make arrangements for the
I will give
children.
it to you, but that's it. I mean, really, it's
No, I get it.
at the next setting, it's player trial. I'm not going to play this game. I will give you the 45 days, but everything needs to be done by that time. Okay?
Yeah.
All right. Sorry, sir. Please.
We have a thing on Mr. Teal, whenever you.
Okay, coming up, sir.
Yes, sir. No, sir.
So what is it? Is it Thial? Mr. Thial, you're charged with criminal trespass of a habitation or shelter. As such, it kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 100 days in jail with credit for the 114 days that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, it will go on your record. From now on, you're facing a minimum of 90 days in jail. Do you understand? How do you plead to the offense, sir? I'm going to find you guilty and I'll send it to the 100 days in jail, give you credit for the 114 days. I'm going to roll your report call so you don't owe anything. Good luck to you, sir.
Thank you, Judge.
Thank you. You too. Take care. Hi. Yes.
Judge, I'm approaching on Mr. Perez. This was a case from yesterday, but it was rolled today. I unfortunately wasn't able to get back here in time to approach on PC.
Really, we're happy that you made it. So you said Perez, right?
Yes, Judge. Jorge Perez.
Or Jorge Perez?
That is Jorge Perez.
Mr.
Yes.
Perez, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. So correct me if I'm wrong, but he was out on bond on this case, right?
Judge, I'm not.
Yeah,
Not
we
sure about
gave him
that.
a general bond and he failed to appear. You know, Mr. Perez, we gave you a free bond and you got out there. All you had to do was come back. And when you come back, good things happen. I want you to listen. Your failure to appear, we issued a warrant. We revoked the bond. You ended up going back to jail and you spent enough time to where immigration was able to put a detainer on you. That's why you were stuck in there now. For future reference, when you pick up a criminal case, come to court because good things happen. Had you come back, it probably could have been resolved in a good way for you. Do you understand?
Yes,
You also need to understand that what you're doing now is you are pleading guilty to the offense of driving while intoxicated.
We're actually approaching on probable cause.
Oh, you are? Oh, I thought you were pleading to.
Judge.
Oh, my fault.
Well,
Well, it may end up good. I don't know.
Actually, once he was detained, he was taken to immigration almost immediately.
Oh, really?
For the GOP bond, Judge.
Okay. I thought he got out. You sent to immigration?
Yes, he was denied bond and he was
Got
returned.
it. Okay, well, he got a bond, I guess, because of the GOB.
Correct.
So you don't think there's PC?
I don't think there's probable cause in this case, Judge.
Do it up.
Yes, Judge. On December 16th, 2024, at approximately 12 a.m., the officers were stationary on West San Houston Parkway when a prohibited vehicle alert displayed a gray Mustang that was prohibited on the toll road. The officer observed that the vehicle was prohibited since August 25th, 2024, and owed $1,536 to the Harris County Toll Road Authority. The officer initiated a traffic stop. Upon contact with the defendant, who was the driver of the vehicle, the officer observed a strong odor of an alcoholic beverage, red glossy eyes, and slurred speech. The officer observed the vehicle to be registered to the defendant, and the defendant admitted to drinking. Standard sobriety were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant considered a breath. The results were 0.067 and 0.065. And the officer further stated that the defendant's VAC would have been 0.085 at the time of stop. And that was whatever that, yeah.
Okay. What's your argument?
So Judge, my concern is that it seems like the police officer has some type of suspicion that he was intoxicated, asked him to do this FST.
No.
Yes,
The
Judge.
stop was initially because it's a prohibited vehicle, right? You owe a crap load of fines and fees to the toll road. You're not supposed to be on the toll road, right?
Right. But I mean, in regards to DWI, Judge, I mean, he asked him to do SFSTs, he conducted those, and he doubled down on his suspicion and asked him to do the breathalyzer. An hour and a half later, he blows under the legal limit, 0.065. That's significantly less. Now, it's the cop's suspicion. Now, at that point, he uses speculative reasoning to believe that it was a 0.08 at the time that he was driving without any type of scientific method or any type of legal actual scientific basis.
Remember, this is probable cause. We can't get into the facts to whether he's guilty or not guilty, whether he's really at a 0.08 at the time of driving. I don't know, but that's why we have trials, to give them the opportunity to respond to what your argument is, because they can't possibly do it now, you know?
Right. I guess my concern is that if you look at the circumstances in totality, I mean, it seems like if the police officer was doubling down on his suspicion, asking to do a breathalyzer, and he passed it, at that point, the other exams were basically just a physical test instead of actually a test for intoxication.
And you may be well right as far as beyond a reasonable doubt. But this is just a probable cause to see if we go forward. Set the case for trial. I think, you know, it would be a great trial.
In that case, Judge, we would ask for the earliest trial.
Yeah, but here we have a good stop,
Yes, Judge.
smell alcohol.
Yes, Judge. Then glossy eyes, and then also, I apologize, let me pull up, and slurred speech. And then after
We've got
that,
all the indicia to begin the DWI investigation, right? Did they do any SFSTs?
after that, they did SFSTs, and they had 6 out of 6 HGN, 4 out of 8 walking, turn, and 3 out of 4 one leg stand.
Right. So I think that there's enough just to go forward for probable cause purposes. Now, set it, you know, you may be right as far as they may, you know, it's good for probable cause, but it may not be enough for beyond a reasonable doubt.
Sounds good.
I have to give them at least, we got to give them, what, 30 days? So we can set up a trial in 30 days. Be ready, watch the videos just to make sure, you know, it coincides and
Just to understand, I have to wait 30 days to set it, or I can?
no.
Now,
Let them know now so that they can get their ducks in a row as far as subpoenas and all that, you know, and is the breath, is what discovery's in.
Yes, and it's completed, yes, we have. We're just missing station video, but everything else.
Okay, that's a big part, you know, because you're gonna need that as far as breath testing and stuff. So, I mean, just stay on top of it. If you want to set it now,
Yes, Judge.
and if you want us to get it a couple of weeks, just to see if we can get the video,
I think
whatever you want to do.
Judge.
Okay, just let Victoria know.
Thanks, Judge. Have a good one.
Judge, are we setting for trial or he's gonna take the
This is
two?
Mr. Elementaris.
You don't need.
I don't think so. The state wants time to evaluate.
Okay, it's 200 days, so we'll give it a week. Okay,
Yeah, we're trying to work it out.
okay. So we'll give you a week. Your guys got to be here at the next time and then so you can,
A week, is it?
a week. Yeah, it's 200 days.
I got 2 files sick next week. Is it possible? The 20th?
What day?
The 20th.
Okay.
Thank you very much.
But hey, Jesse, that's it though, huh? That's it.
Oh, yeah, I understand.
Yeah, okay.
Yeah, it's the second.
Hi, Ramon.
It's gonna be very few options.
Yeah, I know. It's going to happen a lot now, you know? Hey, so the 20th for Jesse's case, clear trial in that setting though. Yeah. Hi. Good morning, Mr.
I
Lee.
have Mr. Khalifa. He is in custody. And
Okay, right?
yes, with the K.
How's Mr. Khalifa?
He is, you
I
know,
can. It's just,
he is very adamant. Say that.
yeah.
So
It's an understatement, right?
his felony attorney, I actually know his attorney that's on his felony, and he was here this morning. And I was talking to the chief, and at this point, it would be time to set these for trial.
Okay,
And
it's up to you.
the
I mean,
asking for 2 weeks to talk to felony to see if they want to dismiss it. But if it does go to trial, I'll need an Arabic interpreter to review evidence, and I think also.
are there videos? Hold on a second. Whoa. Have you looked at the discovery?
Yes.
Is there stuff in Arabic?
Yes, there is stuff in Arabic.
Okay, so you got to go get all that stuff. Hey, they're saying some of the videos are in Arabic.
For the text.
Right.
The text.
So-
Prosecutor.
Remember, we need at least 45 days to just translate that video into Arabic. So get on it now. Are you going to go to trial on this thing?
If they don't dismiss it, I am.
Okay, so can you send it to you need to transcribe it in Arabic. That takes at least 45 days.
Right, and we just have one idiot who works in our office that speaks Arabic and he has his own document.
No, but they send it out. But you got to put in the order now,
Yes, sir.
if you don't mind, please.
Okay.
So,
Right. If they don't dismiss it, we have no reason not to go to
yes,
trial.
hey, look,
Right.
what I'm saying, let's get the order in now.
Exactly.
Because it takes 45 days. That's why.
Well, they may dismiss, but. I don't know.
I know May is a big,
I understand.
I want to make sure that gets done so he doesn't languish in custody because
Exactly.
we can't go to trial until that video's
Well,
transcribed.
no bonding on his felony, and that trial date's October 9th.
Of next year.
Well, this year now, 2025. Yeah.
They set a trial for October of this year?
And he has no bond in the 179th. So.
I have a trial in October, so go on felony. They got set last month.
Should we just get a trial date out, maybe 2 months?
No. I mean, let's just make sure the stuff gets done. Because when you set stuff out that far, they tend to not look at it because they're just so busy. It's better to just keep little settings so we know that we can get on
Could I
top
do
of
like a
on top of.
2-week reset and then we'll.
Yeah, you want to eval it too?
Yes, sir.
Yeah, set it 2 weeks, eval it,
Okay.
and then if it's good for you, start putting the video in to get transcribed. Because he says he's going to trial unless you dismiss it, so, yeah, okay? All right, Bertram. Hi.
Need to get more Arabic speaking cases. Sorry.
That would be an interesting case. Yeah, anyways.
All right, Your Honor, I got Mr. Kabir, who's in the boxes for BVR. I have a feeling you're gonna want to raise bond or do something, so
Come on, Mr. Kabir.
if you were leaning towards that, I would like to request a hearing and have a record on it.
Sure.
But that's only if you want to raise. I hope you don't.
I mean, he tested positive. I've asked him not to use. I've asked him not to consume anything illegal. I've asked him not to consume alcohol. He's still using,
Your Honor, it was, I spoke with pretrial, if, just hear me out for a second.
Sure.
Spoke with pretrial, it's presumptively for THC. Things like Delta 8, kratom, hemp, those are all legal.
I admonish him over and over. This is our third bond violation. If I let him go, I'm enabling the behavior and I'm saying that it's okay to happen. It's a third bond violation, Mr. Kabir. I'm setting you for a hearing in 3 days. You must be here, be ready to go forward. Do you understand? I can't continue. It's a third bond violation.
Sure, Your Honor.
It's unacceptable.
Understand. And look, I appreciate you giving us a little time for the hearing. I was here yesterday as well. We are looking like, it looks like we're about ready to set this for trial anyway. Do you want to wait till the hearing?
If you want to set it, you can, but I'm requiring his presence in 3 days here to have the BVR hearing.
You said 3 days or 3
3
weeks?
days. No, 3 days.
3 days.
So that you can get all your ducks in a row, get all the evidence you need. State, get ready, please, as well.
Yes, Judge.
But, if it was a first, we admonish. Second, sometimes, okay, we're now at a third time.
Yep.
No. Yeah, okay, I'll see you in 3 days. Great. How are you, man? A lot of drama today, man. A lot of drama today.
It seems like it. Want to add more to it?
Okay, it's okay. We still love you, Ray.
Yeah.
What you got?
Gomez, apparently it's O'Deer, Gomez, Santa Maria. It looks like they filed a BBR yesterday for tamper back on the 14th. His appearance was waived today. I didn't get this, so I didn't know to have him here today.
That's okay. So why don't we set it? You want to set it for Friday?
I have a CLE on Friday, so if we could do Monday, that'd be great.
Perfect. Yep. Just let him know he's got to be here Monday. If he fails to appear, the warrant issues.
Sounds good. And that's all I got.
Okay. Have fun.
Thanks. I'm doing well. How about yourself?
Did your guy have a BVR too? Yeah.
Eric Castillo, Judge.
What's going on with that?
On December 31st, it looks like, she reported for.
Positive.
Positive for alcohol.
Is she here now?
She's in the box, Judge. This is a single violation.
Come
Judge.
up, Miss Castillo.
It's the first time we've ever had any issue with her.
So-
We'll say I talked to her right after she learned that she had tested positive. She sounded really sick. She sent me, pictures of the NyQuil that she was taking that had alcohol. And Judge, I'm not gonna sit here and insult your intelligence and try and say that that's what it was.
So, look.
I'm not gonna do that, but.
If you ever test positive again, I'm now amending your bond conditions to put a leg monitor on you, so I know that you're not consuming alcohol. If you ever test positive again, I don't care what it is, I don't care what anyone told you. You know, and you should know what you're putting in your body. I don't care what the excuse is. But if I find that you test positive, you have any more bond violations, I'm gonna lock you up. That's it. Do you understand? Okay, so I'm amending your bond condition, put a scram on her ankle now, and I'll pay for it. Yeah. I want to make sure she's not consuming. If after a while she's not using, then we can talk, but I'm not going to take her word for it. We did that now. And where did it get us? So now I need more physical proof that she's not going to use. So now you're going to have a very cumbersome ankle monitor. You're going to have to explain to everybody what it is. Hopefully you get that. But court orders are court orders, and that's it. You're supposed to follow, and you don't. There are dire consequences. The next time,
PC red on case of 24, please.
absolutely. Who is it?
Mr. Armand Jones, Your Honor.
Where's Mr. Jones?
Custody, Your Honor.
Please.
Yes, Judge. On February 2nd, 2025, officer on patrol on Greens Road at a business called The Spark at 1:36 a.m. and observed two individuals standing outside the front door. The officer initiated a consensual conversation with the defendant and the other individual, and while the officer was speaking with them, the officer observed a clear plastic bag inside the defendant's hoodie pocket containing a green substance in plain view. The defendant stated he had marijuana in his possession, and the officer retrieved marijuana and search incident to arrest found marijuana on the defendant's front jean pocket. The officer knew the substance was marijuana based on training experience, and the marijuana weighed 18 grams.
And I get that he's just going up to a consensual conversation. That's something that they can do. He doesn't have to. He can just walk away. He's not doing anything wrong, but he decides to stay. And the problem is the officer says this is in plain view. Do this. Get the video if there is one. If the video shows that it's not in plain view, come back.
Sounds good, Your Honor.
But the fact that he's saying the plastic bag is out, it's in plain view, and he sees the weed, you know?
Fair enough, Your
So get the video. Like I said, if it doesn't show it's in plain view, come back. Redo it.
Thank you, Your Honor.
Absolutely. We have so much history with Mr. Jones. We have so much history with Mr. Jones. Oh,
Yeah, I saw
it's
it.
the same.
I saw it.
You know, this is probably number what, like at least 12 or 15?
Yeah, we just went over it. I got it. Thank you.
So
Your
you
Honor.
get, so he's got the 2 felony cases. He's no bond. They're set for the 6th, whatever you want.
Thank you, Your Honor.
Yeah, absolutely. Mr. D,
Yes, sir, Your Honor.
Hey.
Approach, please.
how are you?
Yes, sir, Judge. I am here on Mr. Joshua Connor. Judge, this is an old case. It's a 2024 case. But Mrs. Burnell informed me that because the case is still old, that I need to approach you to see how?
So it's 400 days. On January 2nd, it was 2 weeks, THA, plea or trial.
Yes, sir.
We appointed you to it. We're now in February. So what do you guys want to
I
do?
appointed this morning.
Oh, you just got appointed this
Yes,
morning?
sir.
Okay. Mr. Connor, come up.
All the discovery should be available, Judge.
Okay, so what we'll do is we'll give you 2 weeks,
Sure.
and then at that time. So,
I don't think so.
hey, Alex, will you run an NCIC to see if he has any prior DWIs, please?
Yes, sir. Looks like no prior DWIs, Your Honor.
Your case is 400 days old and it's time to make a decision on what we're going to do. I gave you a lawyer today because I'm not going to sit here and wait for months for you to try to go get a lawyer. It's time to make a decision now. I'm giving you 2 weeks from today to make a decision, whether you want to accept a plea bargain agreement from the state. If you do not, within the next 2 weeks, I'm going to immediately set your case for trial, and I'm going to give you an extremely quick trial setting. Do you understand?
Yes, sir.
It would behoove you to meet with Mr. Dixon as soon as possible. All the discovery is in. I will give you no more resets after this time. Do you understand?
Yes, sir.
Okay,
Thank you, Judge.
see you in 2 weeks.
Did we decide what to do for Gonzalez Francisco? Oh, sorry. I
We're
didn't-
waiting for the lawyer to.
Okay, thank you. I'm sorry, I didn't see him in the jury box.
It's okay.
So I'm pushing on Calvin Douglas.
Okay,
Yes.
I think I've been told that a dismissal has been filed.
I don't know.
Uh, I haven't seen it, Judge, but can I ask the state what, can I ask the state what,
Yeah, I'm signing it right now.
it says on there? Was it just,
Insufficient evidence of defendant's guilt.
okay, just because of the same reasons I'm opposing the continuance, Judge, I've got to ask for dismissal with prejudice on this one. Because if the state comes back and refiles, it would be the same effect as.
I don't know. I don't know how I can really, I mean, all I'm going to do on all I do,
Right.
I sign the dismissal. I can't dictate on how
You
they,
could refuse to sign it and,
I'm not going to do that,
okay, Judge.
I'm not gonna
I've got to ask.
Okay.
Thanks, Judge.
for sure. Counsel, how are you? What's new?
On anything, I'm just, I heard something about.
Yes,
Big Van Halen fan,
I am. He's my hero.
a Van Halen cover band.
Was at one point in my life, not anymore. Just, kids have got me riled up. I
It's my
don't even have time to go to the bathroom
first
by myself.
I went to was, beg, borrow, everything I had to do. And finally, parents broke down somewhere between seventh and eighth grade. I went to Van Halen's 1984 tour.
Wow, you saw him in 84. Wow,
The owner,
that's amazing. Was it, how old were you?
I was between seventh and eighth grade, so 12, somewhere. in there.
Was it amazing or what?
Yeah, it confirmed my heterosexuality.
It was the biggest, oh yeah. They were known for their shows, just the debauchery and just,
It's still, to this day, it's still just, it's just another level of
and I'll tell you, the earlier you go with their shows, the raunchier they were, right? But by that point in 84, they're so big. And, MTV had just come into play, right? So their videos were just now coming out that they got so big that like all the eyes were on them. And the newspapers were coming out and saying how the shows were so debauchery, right? And so that's when all that censorship started coming up, when, you know, David Lee Roth is testifying, you know, about being against censorship and this and that. And so I think at that point, they probably
There's
maybe,
the whole, what was it, the Parent Music Resource Center with Tipper Gore and all that. Yeah.
yeah, that's awesome, man. Yeah, there's, you know, on
I
YouTube,
I played too, so.
on YouTube, there's one video of 1984 that they have the entire concert from
Yeah.
beginning to end.
Seen that.
And it's amazing.
It's just, I'm just shocked that there's not more like high quality footage.
They wouldn't, Noel Monk wouldn't let it.
Shows that come out recently, like 81, and I saw 79 show that came out with, and they re-upscaled all the videos, so the video quality was a lot higher. But just this week, I think on YouTube, Dweezil Zappa shared some alternative, what was an alternative? It was a live performance that he knew about, where it was pre the release of Fair Warning, where Eddie's doing basically an alternative version of the Mean Street intro.
Really?
Concert, yeah. It kind of combines that, you know, the little tap, you know, that, you know, with it, which he kind of incorporated into his big guitar solo, like later on.
Wow.
I play guitar, bass, keyboards, drums.
That's awesome. I tell you, it just, I wish I could have been, you know, my folks are just too, they would never, and I was just too young.
You a Mammoth fan?
I'm sorry?
You a Mammoth fan?
Yeah. I haven't listened to much of it.
Telling you, second album is phenomenal.
Really? I haven't heard it. I'll check it out. But he's a lot different though. He's more like, is it Tool-ish, you know?
Well, he's got it's everything. It's like Meshuggah meets the Beatles with some Tool thrown in on some things, but then real catchy pop songs.
I'll have to check it out.
And
I have not heard it.
live, oh my God, they're so good live.
You saw him.
I've seen them 3 times now.
Wow.
Every time they get in here.
Let me know next time if he comes to Houston, because I think the last time did he not come here or did he come here?
I mean, talk about some heavy duty touring. They've been just touring nonstop.
Yeah, that I know. He's been an animal.
We're opening up for Metallica and Pantera on stadium tour. I saw him open up for Alfred Bridge the first time. They were just on the Creed tour. I drove up to Fort Worth to go show, not to see Creed, but to see Mammoth. They came out and just like destroyed. I've got like, I mean, you're busy right now, but I've got there's a song, oh my God, oh my God. Okay. I'm like totally blank.
Is it Mammoth or what?
Song, it's a guitar solo in this song that's oh my God, I can't believe I can't remember the name. As soon as I see it, I'll.
Yeah, show me.
Yeah.
So do you want to talk to me while we're waiting?
Yes, sir.
Show me.
It's called Take a Bow.
Check it
It's
out.
on the second album, Take a Bow, the guitar solo. He used, how nice is this? He's recorded everything at 5150. Uses his dad's original Frankenstrat guitar on
Oh, yeah,
that song.
I've heard that. Yep. Awesome. I'm gonna check it out. Thanks.
See you later. Thank you,
UCD.
Judge.
Yes, sir, Your Honor. I am here on 2 clients. First of which is Edward Burton. He was taken into custody because of the violations of the confirmed drug use. However, I don't believe that was a bond set, and I was wondering.
Oh, yeah. I'll do 2501.
2501?
Correct.
Yes, sir. Secondly, is Gerard Jones, who I understand also tested positive, and correct me if I'm,
no-show.
he was a no-show, did not show up for.
Right, so I'm gonna revoke both of those and then,
Yes, sir, Your Honor.
do you want to stay on or do you want to get
Yes,
on?
sir, stay on, stay
Stay
on.
on? Okay, okay. They were here. You want me to call Day?
Yes, because Miss Gonzalez, Alani Gonzalez, she's wanted out of Louisiana. She's asking for a bond.
Okay, hold on. Hold on.
Calling Day Kim, mobile.
Hey. Hey, I've got Chablis here on, who is it, Chablis?
Alani Rodriguez, I'm sorry, Gonzalez. Gonzalez.
They're not here. No one's here. They were here, but they took off. It's Alani Deontay Gonzalez. And they're coming out.
Okay,
So it'd give me like 5.
I'm sorry.
It'd give me 5.
Yes.
Hey, Jillian, you ready?
I have Mr. Joshua Jones on docket.
Come up, Mr. Jones.
So Judge, at present, Mr. Jones has both a scram device on and a GPS, and he's on a curfew. He's broken curfew a few times, Judge. If you look at the times, though, it's because he's leaving a little early and getting home a little late. The latest maybe being half an hour past curfew. Mr. Jones has maintained gainful employment. He's worked as a helper for a transport company. He's not driving, he's the helper. And so he gets on the truck with the driver, he helps, and then they get back to their site. His wife picks him up from work, and then they pick up their grandkids, and then they get home. He's driving from the east side of town, across the ship channel, down 610 West, and then all the way to 90 into Crosby. It's a long commute, and so due to all that, and his employment is working with him right now. So they typically wouldn't be done at the times they're done, but to keep him on, they're trying to make sure he's done by a certain time so he can make curfew, but it's just a tough commute, especially when he's not the one driving and they have to pick up children because there's only one person that can drive. But he is only late and he only leaves early because of work. That is his only.
You have to understand, you have 2 open DWIs, so it's absolute strict compliance. I never want to ding anyone for working, right? I want you to work because I think that, you need to work. Number one, you need to make money and it gives you something to do so you don't become more self-destructive as it is. I see the violations. We have no alcohol violations, correct? Okay, that's good.
Joshua or?
Joshua Jones, do we have any alcohol violations?
I have no problems now, Judge. Trust me.
I don't see any previous violations, Judge.
Okay, so it looks like most of the stuff, I would tend to agree with you that, upon further inspection, it looks like it may be a little bit here, but there, but prior to. Is all this work related? Okay, so what time do you leave for work in the morning?
I normally have to be to work at 7,
Okay.
most times.
Because I have here that you leave one time here at 5:56 in the morning. So why that early?
Like I say, most times it's anything that I'm leaving is work related. And one of the things that I've been trying to do since I got since I got out was maybe to get in contact with my lawyer to kind of help me out and
But you're not getting in touch with your lawyer at 5:56 in the morning?
So Judge, because it's a transport company, those jobs have different timelines. They are aware of the circumstances, so they try to tighten up on those timelines. But if they have a job and might need him one day at 6:30 or something like that, that's when he'll have to leave early. And he's afraid he's gonna lose that job if he can't comply with what they're asking of him. So I'm asking today, Judge, if we can loosen the timeline a
I'm
little
okay
bit.
with tweaking the schedule.
Okay.
But I want to do it in a real, I'm not going to give you too much leeway. We have to be reasonable about it, right? So I need a time that that's early enough that, you're not going to violate anymore because I don't want to continue to do this, right? So what is a reasonable time in the morning for you to leave?
if he would have asked me to get to work between 6 and 6:30.
How far is it from home to work?
It's maybe a good hour, 10 minutes if it's bad traffic or weather.
What about coming back home? What's a reasonable time?
It's not.
I'm not going to do 9 o'clock. I'm not going to do 9. I don't want you out that late. I will give you a little bit of time after 7 o'clock, but 9 o'clock is too late. When you're coming home here now, you're coming home at the latest at around 7:30. I'm willing to give you, 7:45, 8 o'clock, but that's the latest I'm going to give you.
8 o'clock is fine.
Okay, so Jillian, we'll tweak it 5 in the morning to 8 at night. If there are any more issues, I'm going to lock you up. I mean, I'm working with you now. There should be no more issues. I want you to work. I just don't want you drinking, and I don't want you out in the middle of the night because nothing good happens out in the middle of the night. And I definitely don't want you driving. Do not drive. I don't care what circumstance comes in your life. Do you understand? I'm really going to hit the roof if you drive. Okay. All right, Jillian.
Thank you,
You
Judge.
got it. All right. Good luck, Ms. Jones. Thank you. Deputy Miranda. Hi, guys. So you said it's on,
Alani Gonzalez.
shall we go ahead and bring this person out?
I'm sorry.
Bring him out.
Yeah, you can. Alani Gonzalez.
Do you mind bringing him out, please?
It's a lady, a girl, a young adult. Thank you. I'm trying to hide my little.
Because you got this issue.
Exactly.
Yes, the one that's right next to you. Yes, they're right after you. So, how do you say the sign?
All right. Are you Miss Alani Jones? I'm sorry, Alani Keontae Gonzalez.
Yes, yes.
Miss Gonzalez, your lawyer's asking me to set you a bond. You are a fugitive from justice. There's another state that wants you. I don't know why. I know that you're going to tell me it's little bunnies jumping in the woods but I have to get to know you in a very short period of time. So please, let's get to meet Miss Gonzalez.
Your Honor, Ms. Gonzalez is one out of the state of Louisiana, specifically Baton Rouge Parish, for 2 offenses, the first felony larceny and the second monetary instrument abuse. I don't see that there's a bond there. She has no holds out of any other jurisdictions, Your Honor.
Any other criminal history? Okay. How old is she? How old are you, Miss?
23.
You're 23.
And Judge, yes, that is true. She has no criminal history. She is indicating to me that she lives in Houston. She works in Houston. She
has no recollection of even going to this parish. I've explained to her that you will give her 14 days if you give her a bond to go down there and settle this matter. We have no information about the case that we can give to her. She needs to go to Louisiana and handle that. She understands that. She's never been in trouble, never been in jail. She's asking for you to set her bond so her family can bond her out and assist her in getting to Louisiana to address these issues.
I'm okay with giving her a bond. I mean, it's nonviolent. I don't have any, significant criminal history.
I'm not opposed.
So next question is how much? Amy, guys, what do you say? What do you think?
Six just unopposed to a bond, but we'd be opposed to a loan. Maybe like 5,000.
Judge, I would ask for $1,500. She's 23 years old. She works at a bar on tips. Her family is willing to assist her. But I do believe that based on that information alone, that she's willing to do the right things, go and report back because she knows that you will issue a warrant for her arrest and bring her right back in the event that she does not obey these court's orders.
Ms. Gonzalez, you need to understand.
As a 3-year-old, she wanted me to.
You need to understand that these are serious charges and we take these really, really serious, If you want me to set you a bond, I will. I'll set your bond at $1,500, but you have to understand that you're going to have to probably pony up all of that money. It's not the 10% deal because you're a fugitive, meaning you are a flight risk in and of itself because it's out of another state. I will give you the opportunity to bond out, but I want you to understand we don't play games here. So if from the day that you're released, we give you 2 weeks to go turn yourself into Baton Rouge and take care of the business that you have there. You have to turn yourself in. There's no bond to post there. If you fail to do that, I'm going to revoke this bond. I'm going to set it at 0. I'm not going to give you another one. So if you fail to do it, I'm going to get you back because you can't run forever. And this time I'm going to hold you in custody until Baton Rouge comes and picks you up.
Okay.
You understand?
Yes, sir.
Okay. All right. So we'll set bond at $1,500 and then
I will add she's waived, so she'll be needing to, or withdraw her waiver tonight.
okay. So she did waive.
Correct. On the-
Have you spoken to any family members to make sure that they can make that bond?
No, Judge, I have
Okay,
not.
so the deal is this, is that, we give them 14 days to come pick you up, 14 days from the day that you waive. When did she waive?
Yesterday.
She waived today?
Yesterday.
Yes, so you have 1 day credit toward that 14 days. When you have to withdraw that waiver to be able to bond out. You lose that 1 day credit. And so that's why I would like, prior to you withdrawing that waiver, let Shibli reach out to your family to make sure they can make that bond because I don't want you to lose that 1 day credit, So we can put you back once you verify, or if you don't want to, that's okay too. If you know that they're going to bond you out regardless. I don't know. Sorry?
I can go call them right now.
Well, give the number to Shibli and Shibli can call back there for you and then you guys can talk back there. Okay? And then just let me know.
Yes,
Thanks.
Thank you. All right, thank you.
So once, and if they say yes, at that point, 1,500.
Judge, do you want the other one?
Is it a waiver?
She has not signed it. She's willing to waive.
What's the name?
Her name is Jennifer Claus. She was brought in on Friday. She did not sign. The state is willing to give her the back time for it, but she has not signed the waiver yet. So I don't know if you want to admonish her.
Yeah, I mean, we have to. She's not signing it. She's not doing
Right.
it. Deputy Mayor, do you mind bringing out Jennifer Claus, please? Oh, that's a lot of history right there.
Yeah, she's not.
Oh.
She wants to wait on her train.
I don't see at least prior to this morning.
Good morning, Ms. Claus. So it's come to my attention that you have not signed the waiver So there's two options that we have here. You can ask for a bond or you can waive extradition. Once you waive, we give the demanding jurisdiction 14 days to come pick you up. In this case, it's Orange County, Florida. That's where you're wanted out of for grand larceny in the third degree.
For what, sir?
Grand larceny in the third degree.
That means grand larceny.
Larceny is it's a theft.
Third degree is.
As far as, I'm just telling you what they wrote on the actual, on the complaint, it says I'm sorry, not grand larceny, grand theft in the third degree, $5,000. That's what it says. So if you do not want to waive, that is okay. The waiving, it speeds up the process because we only give them 14 days. If they don't come within the 14 days, Harris County releases you. You got to understand, even if we release you, that warrant from Florida will always remain active until you go back to Florida and take care of it. If you refuse to sign the form, that's okay. We will get a governor's warrant, but that takes 90 days. You're going to sit here 90 days waiting for that governor's warrant to hit. So I will let you make the decision with Chablis, what you would like to do. I don't want you to make a decision here in front of everyone. Take your time.
She does want to waive, and they were gonna give her the credit for Friday when she was originally booked in. They were gonna backdate it to Friday.
Well.
Here's the kicker, though. I just noticed you have an open felony theft case, and you've not made bond on the case. So what happens is that 14 days is typically told until you resolve that case or until you post bond. When all the holds are lifted, at that point, that triggers the 14 days for Florida to come get you. So,
I didn't know you had a case. a
yeah,
local
I mean, I
case.
just noticed it too. So, you can still waive now so that once that hold lifts, it kicks in the 14 days. So, well, I'll let you guys talk about it and let me know.
Yes,
Yeah.
thank you.
All right.
Okay, I'll get the
Ms. Claus.
paperwork. You can sign. It just doesn't come into effect until you handle the paper.
So Chablis, if she waives, there's no need to bring her back out. We'll just sign it and then I can sign it and then we're done.
Yes, yes.
Judge, for Joshua Jones, could you sign the PVR in the queue, for amended conditions?
Do you?
Amended.
Oh, amended condition, got it. Okay.
Sorry.
Brandon. Hey, bud. What's up? Yeah, what's new?
Your Honor, I got a motion of a sub in your queue.
I'll sign it. Just haven't put it in.
Okay, I think they just did, Judge.
Okay. Yeah, I'll sign it.
Tomorrow.
Is it a new case?
It's a little older, but if I have to approach you tomorrow, I'll approach you on it.
Is it, it's that old to where you got to approach them?
Well, I think it's right near 180 days.
Yeah, just whatever you need.
Okay, thanks, Judge.
Sure.
Yes, Judge.
Hey, bud.
Hey, sir, let me turn my camera on. Apologize.
That's okay.
Judge, can you hear me?
Yes.
So, Judge, this morning we pled on Alejandro Navarro.
Okay.
Judge, I talked to pretrial services about his ankle monitor that he had as a condition of bond. I think we thought that the plea paperwork would take care of it. But he's at 49 San Jacinto right now, and they were telling him that they may need an order from the court.
The issue was that when you sent him, the document was not signed. It was signed recently, so he can check in again. But like I had stated earlier to you, don't send the client until it had been signed. It wasn't signed at the time that you had sent him.
It's signed now.
Now it has been.
He should be good now.
Okay. I appreciate it, guys. Thank you very
Okay.
much.
For sure. Take
Bye.
care. Shh.
Garcia.
Garcia.
He's your bond, and he never turned himself in, so I got a copy of the governor's warrant from the state.
Well, wait a second. So, well, that's two different things though. So we're talking about Amber Garcia. Amber Garcia got out.
He got a bond, and he never turned himself into Kansas. He was rearrested.
Oh, I see. Rearrested. Got it. Okay. So we have him here now.
I have a copy of the governor's warrant.
Okay. No, I don't need it. Just serve it and yeah. Good.
He has been served.
Okay, wonderful. And you do need me to sign something though, right?
Yeah, there's a green now.
I think that there's something that I have to sign too, but
So are you leaving your? Yes. Then I guess the judge will just judge. Your Honor, may I approach?
yes, ma'am. Okay, wonderful.
He's currently being held on the road. Yes.
I don't, on, no, there's no, okay. Wait, do you want me to revoke the bond? There's a $5,000 bond that's set. I mean, could she theoretically make the bond and get out? There shouldn't be a bond set. And there's a $5,000 bond set. I don't know why that's,
On this one?
on Amber Garcia, right?
No,
Samuel Garcia.
Sorry.
Oh,
Samuel Garcia. First name
okay.
Abner.
Talking about two different people then.
Okay.
There is a local.
Yes.
There is a local and bond's been made, so I think we're good. I see. Okay, I was looking at Amber Garcia, but this is Abner
Yes.
Garcia. Okay, I think we're good.
Okay.
Yeah. Let me just see real quick, because that's gonna take a bit longer. Eddie. Hey, man, what you got?
Javier Larrega, judges on your docket. 100, I think 60 days old. We provided some materials to the state. We believe that a dismissal is appropriate, Judge. But I think they want to evaluate and take a look at some of the materials we provided.
Okay, so do you want to eval it?
Yeah, we've already done a preliminary eval, Judge. They've provided us with some materials. We're currently looking into it. It shouldn't take that long.
In a week?
Yeah, a week.
Okay, so let's do a week. I'll waive it.
Yes, sir.
And then just let me know if they're not inclined. Are we, we'll end up setting it, I guess, right?
Yes, sir.
Okay, done. All right, got it. Okay, are you ready? Okay. Mr. Gonzalez, come up. Round and around and around and around we have gone. One case, and now a second case, and now we have a bond violation.
Yes, Your Honor. I had spoken with my client on January 18th, the family reunion. My client had ordered an Uber. The Uber canceled on him at about 8:40. And so he was gonna order another Uber. His mother asked him not to do that. She said that she would take him home. And they ended up, there was a Quinceañera, I'm not sure if I'm saying that right. But after that was over, then his mother took him home. That is why he arrived late. That one thing, his mother is here. If you have any questions.
Is that mom there?
Yes.
She speak English? I'm not gonna have you translate.
He has had no other violations. He has 1 day of community service left on his PTI. And he is also currently working and should have the rest of the money for the restitution, which is $2,000.
This is what we're gonna do. I'm sending him for a drug and alcohol test right now. I want to know what, if anything, is in his system. And then we're gonna go from there. So I'm sending you now for a drug test. And then, And then let's just put it on for tomorrow. I want to know what the drug test, if anything, is going to say. Or can you be here tomorrow?
Yes, Your Honor.
Okay. I'm sending you for a drug test now, and then you're up here, right back here, so we can redo everything and see. It's unacceptable. You know what the rule is. You're under strict compliance with 2 cases that are open. This is not the first bond violation that we've had. I'm extremely upset with you, Mr. Gonzalez. I'm not taking any action now, but I want to see what the test says and we'll go forward tomorrow. Okay?
Okay. You want him to come back today?
Tomorrow.
Okay.
I'm sending you for a drug and alcohol test right now. If you fail the test, if you fail to go, I'm going to revoke your bond. I want you back here tomorrow and I want to see what the results are and we'll go forward from there. Okay? Okay.
Gonzalez, right this way.
Hey, I have a motion to revoke. Do you mind signing it, Kelsey, please, in the queue? Ricardo.
Hey, Judge.
Hi, bud. Good morning. Yeah, of course.
Working on Mr. Jonathan Joyal. It's a young man with 2 cases in your court.
Okay, Joyal?
Yeah.
Okay.
Custody Joyal.
Got it.
All right, I'll just print it out. Sorry, I just need to tell where to go.
I guess only one's on the docket today.
Okay.
I don't know. Okay, tell me what's going on.
So here's what's going on, Judge. My understanding, and we're trying to confirm from upstairs in felony, is that he's going to WIMAC based on the new violation in your court of a UCW. So that's causing him to be amended up there and go into WIMAC. That being the case, he's currently in custody. He's only going to be released to WIMAC. So at this point, I'm trying to see what kind of options we have for him. I wanted to come to you to see if he doesn't want to plead to this, how quickly can we give him a trial date if he wants to go forward on these cases?
Alex, do we know 100% that they're going to amend and go to WIMAC?
The only note that I have from the prosecutor in felony is saying that the defense told him the defendant is willing to go into WIMAC, but I don't see any clear indication that that's what they're going to do.
The research I've done.
It happened.
The research I've done on the system and on some of the notes on my end, I don't think they could see it, but it says release to WIMAC only. I looked at the activities up there, and based on all the research, it looks like he's going into WIMAC.
You see, maybe I can see something.
I talked to him as well.
Well, I do see on the same day that note was placed, they dismissed the MAJ and just said that there was a condition amended, so it may be that.
It should reflect in the notes somewhere. I can't imagine that one of the
They left
prosecutors is
explanation
gonna.
blank on the motion to dismiss.
Well, no, I get it, but don't y'all have like a independent notes to, I mean, every time something happens, you guys should notate what
Yes, Judge,
happened.
and the only note we have that says is defense counsel stated the defendant is willing to go to WIMAC to stay on probation. And then they followed that with a dismissal. So I'm imagining.
I see it. No, I see
You
it.
see what I'm talking about?
I see it says, so like I have here 131 amended conditions of probation, order, release defendant to WIMAC staff only.
That's what I got as well. That's
Okay.
mine.
Kelsey,
Yes.
what do you want to do with this case? Because we have these 2 UCWs. While these are open, we can't do.
1 UCW, 1 evading.
Right, I emailed them, Your Honor, and I mean, I need to have confirmation. that
Have you
he's
put an
correct.
offer on this case?
Let me look.
Because maybe you can work something out today. I don't know.
He does, I talked to him. He doesn't want to plead to it.
You need at least 30 days.
Okay.
So they're going to need at least 30 days to get subpoenas out. So it'll be a minimum of 30.
Okay.
So I guess the ball's in your court.
He's going to be in here. He's going to be waiting on a bed in WIMAC. My understanding is there's a 2-month wait, so we could hit trial before. Yeah.
Oh, okay, so
So we could hit trial before he goes off to
yeah,
WIMAC.
what if,
Like a little time to see if felony can respond and see what's going on and they confirm that.
sure, you want to do like a week to see what they,
Yes, that would be
week or
great.
2? Okay.
Okay.
We'll do a week because I know that you're itching to get
The
the,
only thing is I lose a week, right? I lose a week. If we're going off to 30 days, I'm losing a week just by agreeing to this.
no,
Okay.
for that day.
All
And
right, let me talk to my client and see what's going on. Okay, thank you.
sure.
Thank you.
You know what? Continue it.
Continue, yes, sir.
Just continue. Yeah. Yes, Elena. Hi.
Hi, how are you?
What's going on?
I'm approaching on Kareem let's see. My phone did something
I
weird.
forgot what the name was too.
My phone froze up and
Ella Sleen.
yeah, hold on 1 second. And I left my computer upstairs. I was rushing.
He's here.
Yes, he is. And so they dismissed the POM. And however, the theft is still pending. I went through, it's a lot of Target videos. And so,
A lot of what?
Target videos,
Mm.
when I say it's a lot, it's probably about 30. I mean, not 30, but it's a lot of them to go through. And I had not,
Oh, it's only 57 days old.
okay, well, I don't know.
I'm not gonna carry it. If they dismiss the POM, then it's 57 days old. I'm not gonna, you have as much time as you need, what you would with a normal case. You know what I mean?
Okay, well, I just wanted to make sure with that one. So that's, I'm good to reset because I just
Just
wanted to
do-
make sure.
A normal setting.
Okay, I will.
Is
And they're
discovery-
gonna
is discovery
evaluate.
complete?
So like I said before, we're just missing, looks like the body cam and dash, but we have a lot of store video.
It's a lot of store video, non-relevant store video. Okay, thank you.
They dismissed the POM on Della Sleen. So
Can you
Reggie,
hear me? Can you hear me, Your Honor?
hey bud,
Yes, sir.
how are you?
Back from the dead, slowly but surely recovering, Your Honor.
What happened now?
No, after you saw me, I had that amputation, Judge, but then I fell down and I was in the hospital like for 3 to 4 months, Judge.
Oh,
So, no, but
I'm
I'm
so
Judge.
sorry.
No, I'm ever so proud of you, Judge, to watch you on your TV show and stuff. But I'm still working, trying to get back to where I was, Your Honor. But
Okay.
I had a question, Judge. I have the gentleman that I'm calling about, Your Honor, if you still have, I know it's kind of off docket, but since I'm sick, I was wondering if I was going to pose to you a little scenario. I have the gentleman, we have court on Friday. It's a misdemeanor case.
Okay. Do you have a
It's-
cause number?
I certainly do, Your Honor. It's 2549620.
Conseco.
Yes, Judge.
Okay.
It's his first setting, Judge. He does have also a felony that he picked up on out of the same transaction or occurrence. My question to you, Your Honor, is I'm still trying to slowly make it to court, but and I'm going to sign on as attorney of record. Would you like to? What are my options? Waiving his appearance, or should I
No,
send
it's
some?
a first setting. He's got to be here. You can
Okay.
appear via Zoom if you would like,
Oh, okay.
but that's why we have it, make it easier for you. So you don't have to come here. You can appear via Zoom. But this person needs to be here for bond conditions.
I will definitely make him assure myself that he's there, Judge.
Also, have you filed an attorney of record yet, or you're
I will
going
do
to?
that. I'm going to do that when I get to my office today, Judge.
Got it. Okay, so just be ready. I guess let us know what day you want on Friday so we can just reset you then.
Sounds great, Judge.
Okay?
Always a pleasure to see you, Your Honor.
Likewise. All right.
Thank you,
Glad to
Judge.
have you around, Reggie. Take care.
Thank you, Your Honor. Thank you, Judge. Bye.
Okay. Harold, how are you, man?
Good to see you, Judge. So he's charged with Chevrolet threat. I do have it comes out of a shoplifting charge. I think he's in the back and
Yes.
counsel can read the probable cause, but I think it's more just I forget the term for it, just a bravado statement. Hey, if I was in his cuffs, I would kill you and that police officer, I mean, stupid thing to say.
What's the last name? I forgot.
His last is Flores.
Oh, Flores.
Adrian Flores. And I mean, it's definitely a stupid thing to say, not smart, but he does have some mental conditions. So I was going to ask if we're going to follow up motion to get him evaled.
Yes, absolutely. Whatever you need. The problem is every time we give him a bond, he doesn't show up.
Yes, okay.
Yeah, this is a third time. We've already given him 2 priors. He's never shown up on any of them. And now we have him again here. So I don't know anything about the case. So, but if you want to do the eval, we can. And we just go from there. I guess.
I'm not sure if we have all the.
I can't imagine discovery's in yet, just because, I don't know. What say you?
Some of the discoveries in, it looks like we still have a little more to do, it looks like.
Okay.
Video 911.
Oh, thanks. Yeah, so whatever you want, Harold, if you want to set it for an eval, if you want to do something today, if you want to, set it for a week.
And so Judge, on the bond, do we need to talk about that? I mean, they're required when they're, I guess it's not his first arrest, but, we'd like a chance, I guess, to talk about it, but I guess if we could prepare a little bit.
Sure. Yeah, whatever you need.
But you don't need to bring him in here today and talk to him. Okay.
No.
Okay, so I guess I'll turn on the eval for that one. I'm sorry, the mental health evaluation.
Okay.
And then we'll
And
go.
if you want, I'll do the bail order for you, so you don't have to do it. And just whatever day you want. If you want to do the mental health eval, we'll have to do a 30-day setting. And just, we file the appropriate paperwork, and then we'll have him, evaled, and then we'll come back.
And you just said you're gonna do the paperwork for,
The bail order, I'll do it for you.
you mean for the mental health evaluation or you mean?
No, bail order, because we have to do bail orders on all the people that are in
That's
custody.
something hearing, okay.
But where do we get she's printing it out for you. So just write Y and then I'll sign it for you.
I know, of course, do all these things differently.
Yeah. Oh, let me go ahead and do that now.
Oh, so we're done with this one. Yeah, I just have one more. Are you getting ready to take off, Judge? Or? Okay, that's one more to ask about. Let me look it up here. I'll be right back. Sorry.
Do you want to talk about something else real quick?
I had one other one. And here's the,
Okay, great.
Since she signed the waiver, we're gonna set her bond at 1,500 for the silence.
We're setting the bond at 1,500, right? For,
Gonzalez. Cause she came and gave it to me after she signed, but she didn't reapproach with you.
yeah, she didn't say definitively whether. Yeah, of course I wrote it on the docket, and I'm assuming that because she filed that we're gonna set the bond at 1,500.
What is it, a withdrawal?
Yeah.
Yeah, it's a
Oh, then
waiver.
yes.
Yeah,
If they're-
okay. Harold, talk to me.
just, I've got a case number. It's, oh God, dog it. There's one over
Is
here.
it Flores, page 32?
So it's case number 254, Judge 8810. This is a new case I had last week.
On Patterson,
Yes,
254.
Neosha Patterson.
Alicia Patterson, yeah. This was on last,
8810.
it's set for April 3rd.
Yep, so I just noticed I didn't get a chance. You ought to have read the probable cause before I got in here, Judge. But I noticed that, I don't think it meets the probable cause. I was gonna see if we could read it.
Yeah, absolutely. So, you want to do a probable cause hearing?
Yes, we can.
Okay, absolutely. Please.
All right.
Did you get it? The cause number?
Yes, what is it, criminal trespass, is that the one we're on?
Yes.
January 24th, 2025, Leo dispatched to apartment regarding family disturbance. Law enforcement officer made contact with complaining witness and former dating relationship with defendant. Stated defendant has been banging on door of her apartment since 1/23/25.
Yeah.
Defendant did not make any threats or say anything besides banging on the front door. Law enforcement officer observed defendant moving around rear seats of complainant's motor vehicle. Complaining witness approached her motor vehicle, claimed ownership, and ID'd defendant as person inside. Complaining witness stated she had recently got a motor vehicle, had not let defendant borrow a motor vehicle or use it in any manner, and also stated that she secured all the seats. Defendant stated motor vehicle was already unlocked, and law enforcement officer did not observe signs of forced entry.
So just for trespass, you gotta either have been warned before, don't come around here, we don't want you here, or you're there and then you're told leave and you don't leave. So this doesn't fit either one of those. I mean, the door's already unlocked in the car. She's never been told not to go in this car, stay there. In fact, this is the lady that the complaint witness was here and
I remember
asked-
that she was here.
They stayed-
I,
They have a bit of a history together as well. I think there was a prior where the complaining witness.
so the trespasses were with regards to the car,
Yes.
okay? Did the complaining witness tell her to leave and she continued to stay? Or was there some kind of notice prior that, hey, I don't want you here, or, hey, go through it one more time, will
She
you?
did not let her borrow it or use it in any manner.
She just took the car?
She was just in the car.
She was just in the car.
It was cold that night and she was trying to get in and, I know this isn't here, but the complaint witness told me that she didn't hear the initial call, initial knocks on the door. It was later when she reviewed the Ring camera that she saw her at the door since then, but she heard at the last few, the knocks or whatever. And that's when she viewed the camera and then called the police. But I think it was more of a situation that she wasn't sure about her mental state. I know this isn't here either, but that's what she told me.
Right, but we can't get into the facts that are out because that's not fair to them, right? Well,
She shared with one of the prosecutors, he's not here today. I forget the young man's name. And talked to Shisley with him.
Oh, with Alex?
Yeah.
He did speak with her. Absolutely.
So did she tell her to get out of the car?
Well, she didn't let her in her house, which
Right, but she's charged with the trespass of the car, right? So did she, at what point?
no, but she did go out of her way to say that she has never let her use the car, never borrowed it, let her borrow it in any manner.
So she's just in the car when the cops roll up?
This fact pattern, yes. That's what I understand, having not spoken to the complaining witness myself.
How did she know that she's not supposed to be there? Because from what I understand, they're in a relationship.
Well, prior dating relationship.
How much former?
Not sure of that, Your Honor. There,
Is it something where you broke up 6 months ago and you're not supposed to be in the car, or is it something where it's,
there was a previous charge against the
I mean, let's look at the statute. Hold on.
defendant for stabbing the complaining witness. So
Say it again?
there's a previous charge against the defendant for assaulting the complaining witness. So I would imagine there's not supposed to be.
Well, remember, we don't work on hunches, right? It's got to be
Yes, true.
definitive. Texas Penal Code, criminal.
It's 30.05, I guess.
A person commits an offense if the person enters or remains on or in property of another, including residential land, agricultural tract, recreational vehicle, park, a building, had notice that entry was forbidden, or received notice to depart but failed to do so. Did she have notice that entry was forbidden?
Doesn't appear so, Your Honor. They had been broken up for a couple of weeks at this point. I do.
But Harold, if you're broken up, or should know that you're not supposed to be there, right? I can't just go to someone's car, enter the car. I know it's cold, but that doesn't give me the authority to just go in someone's car and sit in it, right?
Well, it was cold outside. and
I don't
she knew it
care.
was her
Even
car.
if it's 100 degrees, you can't just go into someone's car, and just stay there as justification for criminal trespass.
Well, but I mean, we're also justifying the state filing these charges, Judge, by them not having the complete amount of the facts and here, the elements. As far as, just like you read, like I said at the beginning too, that no notice entry was forbidden or
Well, no,
receiving notice.
but if you're broken up with someone and you're no longer in a relationship, you can't just go into that person's car and assume that you have authority to go there, even if it's 2,000 degrees below Fahrenheit or Kelvin, right? I- it- that, it just doesn't, it doesn't jive. It doesn't make sense. I don't think that that would be a reasonable interpretation, you know? If they were in a relationship, in a current relationship, then I think that that would be reasonable. I think that that would be okay where you could go into there. But if they're not in a relationship anymore, I think that that would be, I don't think that would be reasonable, you know? If you show me something different, then, and I'm all with it, right? But you know, or you should know at that point, you can't just go into someone's car.
I understand, but I did check the report too, and the report mirrors this exactly. So they've got no other evidence, so they might even.
Well, Judge, she hadn't moved out, so she had taken her stuff and moved off the premises.
She had moved on.
She had moved out over a month ago.
Right. So that's what I'm saying. That adds credence to that. You can't just go into someone's car. I know it's cold. There are other places that you can go. And I don't think that that's a reasonable justification
Yeah, the month.
to violate.
I understand. The month, facts are coming from the report. And in that report, she does tell the officers, I saw stuff in there. I live here. You know, my client says that, but we might be able to work this out. I understand.
Right. But nevertheless, they had broken up. She moves her stuff out and she may be saying that to the cops, right? To be able to not get arrested, right? But what we have here is that they're no longer in a relationship. She's moved on. And yeah, I think that there's enough, you know? Sorry, Harold.
Thank you.
Okay. Close.